So everyone be mindful of what you're saying now. How's official.
All right, good afternoon, those of you who are on Zoom. We will get started in about 1 minute. Oh, okay.
It won't let me do anything when it's not that it was burnt. I even went in and saw it, I didn't think anything. Yeah, and if I have, when I put my foot in, it pops up like probably 10 times, and I can't do anything until it's popping up.
Do you want me to check on it?
I deleted it.
All right, because we want to be mindful of Dr. Bryan Taylor's time, then I will go ahead and start by introducing him. So Dr. Bryan Taylor is the prosecuting attorney for Canyon County, and he has held that position since 2010, but he has been a prosecutor in the state of Idaho since 2001. As a deputy prosecutor, he oversaw Canyon County's special victims and crimes against persons units, handling and supervising cases ranging from sexual offenses and domestic violence to homicides. Dr. Taylor holds a BA in political science from Boise State University, a Juris Doctorate from the University of Denver College of Law, a Doctorate of Philosophy and Education from the University of Idaho, and a Master's in Theology from the Notre Dame Graduate School of Christendom College. He is currently, as if the alphabet behind his name was not enough, he is currently pursuing a judicial licentiate in canon law from St. Paul University and a master's in canon law from the University of Ottawa. Dr. Taylor is also an experienced educator. He has taught classes for a number of universities over the past 19 years, including Boise State University, University of Idaho, Belarus State Economics University College of Law in Minsk, Belarus and Concordia University of School of Law in Boise. He has taught courses in 6 different countries to prosecutors, law enforcement, victim witnesses, judges, and others. Dr. Taylor lives in Caldwell, Idaho with his wife, 2 children, and dog. So we are very privileged to have Dr. Taylor with us here today, and so thankful that he is a resource that is just down the road for us. So thank you very much, Bryan, for being here.
Can everyone on the Zoom call hear me? So if you cannot interrupt me or stop me now. So we're getting set up here. And I apologize for the long intro. It's my original intro was, "Hey, I'm Bryan." That's all you need to know. So, but they wanted more. They wanted more. So.
Now we're duly impressed.
Oh no, don't be. We'll see if I can hold up to it. So, no, this is a brainstorming idea that Jeannie and I had about a month and a half ago. We're just sitting and chatting of what might be of interest or insightful for those who are working at the Family Justice Center. And that was sort of how the court system even operates. Is you see, right, the television and the movies. I always like to think of myself as Jack McCoy from Law and Order, but I'm not. Sometimes the system can be quite convoluted, confusing. When you're working with survivors, sometimes it might be helpful just to have in the back of your mind, where is the process when they're using these terminologies and sort of different hearings and how long the process goes. That's what prompted this conversation with us. And as we go through this, I'm going to try to make it as simple as humanly possible. Stop me, ask me questions. Those online, I took the microphone off of me as I've been trying to work out, but clearly I'm not very well. This is the COVID look right now. And so stop and interrupt me. I'd rather answer the questions that are on your mind as we go along than wait until the end or anything to that effect. I have a little handout. I didn't realize there was going to be I didn't realize this was going to be Zoomed. I thought it was just being recorded. So I will get you the little handout, and it's a one-page handout. It's sort of the complex flow of the justice system is just this is a general idea for the United States. We're going to focus a little more Idaho specific on that as well. So, and if there's something else you want to talk about, just bug me at this stage. So, okay. So in order for, when we think of the criminal justice system, before we even get rocking and rolling, they call it a system for a reason, right? Is when you are in high school biology, you're studying the human body, right? How the respiratory system impacts the cardiovascular system or the nervous system. It is, you need all these little miniature systems for the entire body. The criminal justice system, think of it as the entire human body. And each one of us has different parts and responsibilities for the system to operate. The two biggies, or I guess really the three biggies, because of Hollywood and everything to that effect, is really the courts, when you see the judges, right? The police, who investigate the crimes, and the prosecutors or district attorneys who prosecute the offenders. Those are what Hollywood depicts, but there's so many other integral parts of the system. So we're only going to focus on one part of the entire system today, and that's the court process. I'm not going to talk about too much of what law enforcement does, but it's usually law enforcement that generates the crime, right? Coming into the system. They're not the ones that create the crime. They're the ones that investigate. I probably should stand a little more clarity there, right? So, but typically a crime has to be committed before the criminal justice system itself from the court process even begins. So crimes take place all the time in which law enforcement may never investigate. Here at the Family Justice Center, right, is how many individuals have experienced domestic violence before law enforcement's even called. Doesn't mean that a crime hasn't been committed. It's by the time it begins to be investigated. Does that make sense? So for the court process to start, the very first step in the entire system is the crime's been committed, and now law enforcement begins to investigate the report in that aspect. There are generally three types of crimes with regards to our system. Every crime in Idaho can be classified into one of these three categories. And the categories are really defined based on the punishment. So we think of infractions, right? No one needs to raise their hand. But if anyone's been stopped by ISP on I-84 through construction zones for speeding, that would be constituted as an infraction because the maximum penalty that can be imposed is a monetary penalty. So fine. Right? I think the going rate for a speeding ticket now is like $90, something to that effect. And then the other two big ones that you would work with, you will never see the infractions probably at the Family Justice Center, right? It's, but the next two you will, misdemeanors and felonies. And once again, the misdemeanors are defined by the maximum penalty that can be imposed as incarceration at the Kane County Jail, which we have no space. So, and then the maximum penalty for a felony typically is prison. In Idaho, we still have the death penalty. So for first degree homicide, it is really the only crime in which you can be executed in the state of Idaho. But usually that's the distinction between the two is prison versus jail. Some crimes may fall into both categories, right? So we think of domestic violence. There is a misdemeanor level domestic violence that doesn't have some type of traumatic injury versus a felonious domestic battery that does have a traumatic injury. And depending on how the courts identify those definitions, I'm not going to go into. But each one of these crimes has a different path through the system. Naturally, the infraction process is a very simple, very easy process. The misdemeanors are a little more complex. But we're going to focus primarily on the felony one today rather than going into all three of them. If you understand how the felony system works, everything else is cakewalk in that aspect, right? So, once again, law enforcement begins to investigate the crime, whatever it shall be, right? This was the one up on the, since I'm pointing to it, the one in the upper left-hand corner is felony domestic battery. She was beat with a baseball bat. And the thigh, that was, I think, within 24 hours, you should have saw it afterwards, right? Another individual up in the upper right hand, he was charged with numerous gang crimes, right? But law enforcement's investigating. Then you down here on the bottom right is your guns, your methamphetamine, your marijuana, the classic drugs that are in Canyon County, or even health and welfare checks of wrongful places that kids should be at. But whatever it is, law enforcement is investigating it. And when they're investigating it, for the crime to enter into the system, we look at it, what we call the burdens of proof in the criminal justice system. Is think of it in a simple aspect of a definition is you have to establish one, that a crime has been committed. And the second question is, this is the person that committed the crime. So let's take one of the crimes that you would deal with here at the Justice Center, and domestic battery, right? A felony domestic battery is you have to establish that somebody on a certain date in Canyon County, Idaho, unlawfully touched another human being that was a spouse, a household member, something to that effect, and caused traumatic injury to that individual. That's the crime. The second part is, this is the person that did that crime. So it doesn't matter where you fall on these different levels, you're asking those same two questions. So in order for the police to arrest somebody, you see those yellow box of probable cause, is they have to establish, more likely than not, that that crime of felony domestic battery took place, and Bob is the defendant. For me, I have to prove beyond a reasonable doubt that the crime of felony domestic battery is taking place and that Bob is the one that did it. If there is a disconnect between law enforcement and prosecution, it is that we see the world in two different lenses. And this is one of the big different lenses here, is we're looking at it as, can we prove this case beyond a reasonable doubt that a crime has been committed and it's the person that did it, versus do I have enough to arrest them? If you don't get to the yellow, you don't really come into the criminal justice system, or the court process, I guess I should say. So you cannot, the US Supreme Court and the Idaho Supreme Court says you can't calculate percentage-wise of any of these, but we're going to calculate it to help you understand it here. So what do you think probable cause means from a scale of 0 to 100? What do you think? And once again, the official definition, more likely than not, that crime of domestic battery has taken place, and this is the person that did it. 51%. Okay. Anyone else have anything else? It's a pretty stinking good guess, right? What about for the prosecution? In order for me to convict somebody before a jury, I have to prove beyond a reasonable doubt. What do you think that is on your same scale? Huh?
15.
Well, it's up here. It's going to be much higher that I have to prove.
Oh, that you have to prove.
I have to
Okay.
prove,
Because
right?
they
That's the
have to
highest
get out there.
burden in our
Okay.
system, is you have to prove somebody beyond a reasonable doubt. There's no reasonable doubt this is the person that did this. What do you think?
95.
You guys have seen my slides, haven't you? There's nothing in the world that is absolute. So I would say around 95% likely, right? So you can already see there's a massive difference between the way police see the world and prosecution sees the world. The burden to arrest somebody is very low. To convict them is very high, which it should be in our system too, right? In order for them to stop you, all they need is reasonable suspicion, which is around 20 to 30% for them to investigate the crime. And then the other two are more in the world of technical aspects like suppression motions or evidentiary hearings. So you don't really need to know it, but you can kind of see. But everything left of the red is they're innocent. Once you get beyond the red, that's where they're deemed guilty of the crime. Make sense? So in order to get to start the court process, we have to at least be in the yellow in this stage. So just a break, right? One of the things we always get every morning, we get all these new cases that come in from law enforcement. And sometimes you get to see the booking photos, and before you see the charges, you try to figure out what they've done. So, right? These are some of our Caney County folks. So what do you think about the gentleman here? That's a Sharpie marker. What do you think he did?
Tried to rob something.
Rob something? Yeah, right.
Paraphernalia.
Yeah, paraphernalia. Yeah. He worked at the haunted maze,
Oh.
and he was engaged in or had some illicit contact with minors. So those minors may have been individuals that came through the Family Justice Center. What about our lady next to him?
DUI.
DUI? Yeah, she embezzled $1 million from the company.
Wow.
What about the young gentleman here?
He looked battery.
Yeah, he was a child. He was, I think, 13 when that photo was taken.
So based on that, I'm saying murder.
No, close.
Battery.
Tempted.
Yeah.
This is Trevor Reisenstein. If you recall, he picked up a little girl who was walking home, raped her, and then tried to kill her. And then what about this gentleman down here on the left?
Armed robbery.
First degree murder. He zip tied the gal's neck, and he ran away from law enforcement. My favorite is this one because the shirt's awesome. It shouldn't hurt to be a child.
Hey, Brian,
Yes.
are the things you're showing on the PowerPoint slides? Because we're only seeing the initials PowerPoint slide that you put up.
Oh, you're not seeing the bookend photos right now?
Exactly.
Okay. I have technology gurus coming.
Okay. Okay. Perfect. Thank you.
Yeah, no problem.
So
Yeah.
what are you seeing on your end?
It says the court process prosecuting attorney Bryan Taylor. Slide number 1.
Oh, geez. Yeah.
Zoom.
Oh, it's Zoom. And you share,
Well, Zoom should show that. What's on this screen? Go in and do that.
it's shared. It says, yeah, it says you're sharing it.
Stop sharing and then share again.
Mm-hmm. Okay, let me see.
Anybody, felony injured child.
Oh.
Then the last one was gang, or no, drugs.
How about now? What are you seeing?
That's perfect. Yep, I see 6 people.
Okay, let me move forward real quick just to see if it continues to do what we want it to do. Can you see the next slide?
Yep, screening and charging. Yep.
Perfect. Okay, hopefully that'll fit.
So since our Zoom folks haven't seen it, this is the one slide you need to know, because I'm going to use these terminologies as you heard. So the yellow is the probable cause, and then sort of the brown is the beyond a reasonable doubt. These are the two standards that I'm going to use a lot of the terminology throughout. So questions, comments, thoughts up to this stage? Nothing? Okay.
So what percentage of cases make it up to you?
In what aspect does that, I guess,
From starting from reasonable, well, probable cause.
well, I get 100% of the cases that law enforcement submits to me.
Really?
Now, whether or not law enforcement submits it to me is a whole different ballgame. So I don't have the numbers of how many crimes occur out there that I never see. I don't have those numbers. That would be our law enforcement partners that would have that. So, but when in doubt, if they're investigating the case, whether or not we charge or not charge, which is this step, is everything comes to my office.
I guess that's what I'm asking, percentage of charged. get up to?
Out of the cases that are presented to me, maybe 20 to 30% of the cases that are brought to my office are ultimately charged.
Okay.
There's a large volume of cases that we may not know suspects. There may not be this beyond a reasonable doubt, right? So when I get a case, we'll see here in this next section, I'm eyeing it and I'm reviewing it of whether or not I'm going to ultimately be able to prove this case beyond a reasonable doubt. There's many times in which you know the person did it, you just can't prove it in a number of aspects. And when we're looking at it, I'm not going to go into all the nuances, but right is you have the criminal code, then you have all the case law. Then you have to understand all the rules of evidence. What evidence can I use? What evidence can I not use? What evidence is going to get tossed because the police may have done something inappropriate or wrong? Whether or not the victim's credibility comes in, not comes in. So we're looking at it from this massive view. So in that aspect. Now, the cases in which law enforcement submits to us that there is probable cause, what we actually charge is probably much higher. We're probably at 80% of those cases are brought, but a lot of them that are presented to us don't even have probable cause at that stage. So what ultimately happens in this very first step, right, is law enforcement investigates this case. So let's take, we'll use the same example through the whole process, is we have this felony domestic. Police go out to the scene, they start investigating it. If the suspect's present, let's say our suspect hit the victim, she has a black and blue eye, bloody nose, scratches all over her. All we have is her statement that he did it. He doesn't say anything, but he's present. Okay? That's going to be our fact pattern for the class. Okay? Law enforcement can do one of three things when they're investigating the crime. So if we go back to our very first one here, right, is the crime has been committed. Something happened to this lady in this situation. The police have a couple options available to them in our system. The police legally can do nothing. Say, let's figure it out, right? We're on our way. Our law enforcement in Caney County don't do that, but legally they have that ability, just like they do when you get pulled over for that speeding violation. They can give you a ticket, but they don't have to. Depends on what they want to do. They could arrest the individual. It's a felony. The individual's present. They would probably have, based on the facts that I've given you, more likely than not, a crime's been committed. And based on her statements, it's more likely than not, he's the one that did it. Now, whether or not we're going to prove it is a whole different question. But to arrest him, law enforcement could do that. Or the third option in which they can do is they can route the case to my office, and then we make the determination, okay, all I need is probable cause to charge, but do I want to charge it? Am I going to be able to prove it? That's where your forensic interviews come in. It's where conversations of the victim, right? Depending on what other type of evidence. Do we have other previous history between these two individuals? Maybe we need to send out investigators to talk to family and friends. Whatever that shall be, we may want to slow down the whole process. But the prosecutor in the world of felonies, law enforcement can arrest, they cannot charge. Only the prosecutor in the state of Idaho can officially charge a felony. Police can charge misdemeanors and infractions, but they cannot charge a felony. So the media always gets it wrong when they say police charged this individual. No, they didn't charge him, they arrested him. Then it has to be screened. This process of, if they arrested him, in our hypothetical, it has to be brought to my office within 48 hours. And I have to make a determination of whether or not I'm going to charge, I'm going to say no to the whole process. Yes, ma'am.
Yeah, it has to be brought to your office within the 48 hours of the arrest.
Of the arrest. Yes, if they don't arrest them for a felony, I have 5 years. But if they arrest them,
Okay, so they can still do an investigation, yet not have arrested?
Yep,
them. Gotcha,
yep.
okay,
Once they arrest them, it has to be brought before a judge within
Gotcha.
48 hours.
okay, that makes sense.
So, but up to that point, you have a statute of limitations for all the different crimes. In our domestic felony, it would be a 5-year period that they would have it. To officially charge it, all I need to establish before a judge is that there is probable cause. So that yellow box, 51% likely, right, that there's a crime. And if I decide to charge, I put together an official document that's called a complaint. So it's from everything that is our system comes from the English system, right? Is the king or the queen in the English system was complaining that a citizen was violating some social norm. That's all ours is, right? Is the state of Idaho is complaining against Bob for committing the crime of domestic battery. That's all it is a complaint. A complaint is the exact same thing as that speeding ticket. It's all rooted in the Fifth Amendment, tells you who you are, what crime you're being charged with, who's the accuser, right? Goes through all the details. The police just can do it in a very small document where lawyers were verbose. Ours are long and very wordy, but it does the same thing is we initiate a complaint. The state of Idaho is now initiating. So it's not the survivor, not the victim, whatever terminology is going to be used at that time is not the individual pressing the charges. It's the state of Idaho, which is me. So I'm looking at it not just from the victim's point of view, but what is in the best interest of the 220,000 individuals of Canyon County. Does it make sense? Because that's who I represent. I represent the people, not necessarily the victim. So questions up to this point. Making sense so far? So we do this every single morning. Is we average around 10 to 20 new felonies that are brought to our office every day. So and we have to screen these quite quickly and make a determination of whether or not to charge or not to charge. Once charges are filed, so right here, we can go down one of two routes. The first route is the most common route. Almost every single domestic violence case would go through route one, which is the preliminary hearing process. So a complaint is generated within this 48 hours. They have their first appearance, which is called the initial appearance. And at the initial appearance, they're brought before a judge, and the judge is determining whether or not there's probable cause to keep the ball rolling, so to speak. So if you think about it, up to this stage, and we're only on the second step of the process, is the police officer made a determination of probable cause. The prosecutor has made that there's probable cause to keep the case moving. And now you have a magistrate judge who has made the determination of probable cause. So you have 3 checks in the system already within this very first, because of the nature of the crime, it's very serious. The system is designed to protect the defendant in every aspect. So at this statement, the judge has made a determination of probable cause. The judge also goes through all the litany of rights that an individual citizen has. Here, so you have the right to confront your accuser, right? Probably have heard those, right? So you have the right to a jury trial, right? You have the right to this preliminary hearing. The judge goes through all the litany of rights to this individual of what their protections are. They have one of the biggest rights here is, right, is if you can't afford an attorney, Canyon County is providing you one. So this is where they would get the public defender appointed at this stage. And the other big thing that happens at this initial arraignment is bail is set. And for a lot of the cases that you deal with, I guess you could throw another line here, just thinking about it, is this is where no contact orders would be imposed at this particular hearing as well. But the judge then sets forth the bail that is appropriate on this particular charge, right? And bail can range from anything being released to their own recognizance. You'll hear the terminology or vernacular that somebody was released OR, right? I always say, is the criminal justice system is like the medical profession. You start using the slang and terminology that you may not know. So ROR is released on own recognizance, right? They could be put on electronic monitoring through the sheriff's office, home arrest at this aspect, so they're not staying in King County Jail, or bail is set. And that can be from $1 to no bond, depending on it. Everything in the world of bail is dictated by our 8th Amendment of the Constitution. So basically, you're going to get some form of bail where you have to post it. So the general rule of thumb, the bond and bail system is so convoluted and doesn't make sense. But it's usually you have to post 10%. So you go to a bail agent. If you have a $10,000 bond, I use bail and bond, they're interchangeable words, sorry. If you have $10,000 bond, you need to come up with $1,000 to that bail agent. And then the bail agent posts the other 9,000. It's kind of like an insurance. As long as you keep showing up to court, then the bond agent covers it all. Is if you skip your bond, then the bail agent comes and hunts you down. Dog the bounty hunter, anyone seen, right? And then you're on the hook for the other 9,000. And then they come after you for that aspect. Does that make sense? So the bail is basically to assure that this person, hey, money is going to assure that this person shows up. You keep telling yourself that. So right, these are the two primary factors that are made in arguments of bail. So at this initial hearing, one of my prosecutors is present and argues to the judge that this particular individual is a flight risk, right? So the bail needs to be higher if this person's going to jump. The whole purpose of bond is for this person to show up to court. So if we already know this person has, you'll hear this other term, FTA, which is failure to appear. We keep a list of every time somebody doesn't show up to court, right? That shows a proclivity to a flight risk. If an individual is potentially an undocumented immigrant to this country, they are deemed, based on the court opinions, that they're a higher flight risk. They may be fleeing the country, right? Is if the person has a whole bunch of family, job, kids, everything else here, yeah, probably a stronger likelihood that they're not going to just leave the area. And then what is their danger to the community? So this is where the no contact orders are utilized, right? Is, hey, if it's a domestic violence case, naturally, the danger to the community is not necessarily to the community as a whole. It's more to the community of the family at that aspect, or the household. Does that make sense? How the logic works? So this is an example of what a hearing. They're very fast processes. This lady is going to get charged with, or has been charged. So she committed the crime. She's been charged with possession of like prescription meds and stuff. Okay. You're going to hear some term of art like the RORs and all that, but you're going to see the judge going to hear the crimes. He's going to identify what rights, and then he's going to start setting bail to each one if there's any conditions to the bail. And it's a fairly fast.
Like it's over, you'll be charged with possession of Xanax and BARS. I don't know what it is. Xanax bars. Xanax bars. All right, I understand you're ready to work for hotel service.
Yeah, no objection, she had no prior.
No prior history.
So are you working?
Yes,
How much money are you making a week approximately?
approximately about $200 a week.
And do you own any property that?
I'm going to pause it for 1 second. So the reason why they're asking all the questions with regards to how much she makes is to determine whether or not she can hire her own attorney, or whether or not the state is going to have to provide one. So there's a certain threshold that we have a calculation of whether or not they get it. So that's what they're trying to determine right now, if she's going to represent herself or not.
A house, a car, bank account, significant amount of jewelry.
Yes,
What do you own?
I own a lot of jewelry, all right,
Uh,
as well as
Go
a
ahead.
car.
How much would you say your jewelry is worth? Well, it's not a joke, you know, we're not in a club now.
Okay, but if you
Hey, well, you see, we're not in a club, be serious about it.
I'm serious about
You're
it.
being
You just
very,
made me
I can
laugh.
see you're serious, all right?
You just made me laugh. I apologize.
It's all right, how much is your jewelry worth?
It's worth a lot of money.
Like what?
Like Rick Ross.
Huh?
It's worth
Ma'am,
money.
have you had any kind of drugs in the last 24 hours?
Actually, no.
Actually, no. I don't even gonna appoint you because you own a lot of money, substantial amount of jewelry. You can go and sell your jewelry for a private attorney. What is the standard bond?
It could be,
Ain't gonna be no PTS.
okay, 5,000 on count one, and then the rest should be ROR.
Release on her own. So bond on one charge and then.
Oh, yeah, the thing also requires a referral to Division 51. Because there's no.
Count one will be 5,000 for our cost found. Count two will be
$5,000.
ROR.
Division 51 ROR, count 2 through 26.
And refer to Division 51. Bye-bye.
Adios.
Come back, man, come back. Come back. Let me paper again. Count one would be 10,000.
Are you serious?
I am serious, adios.
And she puts them off.
Come back again. Come back again. Bring it back again.
Reality is so much better than fiction.
What's
I
up?
heard you saying to, I believe you, did you say that? Oh, you did say that? I find you in direct criminal contempt, 30 days in the county jail.
So that's kind of an example of an initial appearance. They're very quick. If you're ever interested to see how the process, everything in the adult criminal world is open to the public. That's one of our, right now it's not open to the public because of COVID, but constitutionally, everything should be open to the public. And you can see these arraignments every single day at 1:30. Just there's a number of them, right? So every one of those felony cases in which we charge, if there's 10 to 20, plus all the misdemeanors or anyone else that was arrested, we go through the litany of this. So they're very quick and efficient in that aspect. So something I always like to do is I'm going to give you a couple cases. If you were the judge, what type of bond would it be? Okay. So our first one, and remember our two primary factors are what that you're going to consider bond? Flight risk, endangered community. So our first one is, here's Billy. He's caught with a small baggie of meth, drug of choice in Canyon County. And he admits that the meth is his because he's an addict. Okay. Billy's a lifelong Canyon County resident, born and raised in the 2C. His family lives here. He has no job, but he has a really lengthy criminal history. He has two prior felonies, the burglary and another PCS's possession of a controlled substance. So this is number 3. This makes him a habitual offender, sort of the 3 strikes component. So we can add a potential life enhancement on Billy on this charge. What do you think? What would you put the bond? And feel free, if you're online, if you want to pipe in on the discussion, feel free. Anyone want to take a shot at it? And then I'll kind of give you what a Canyon County judge most likely would give.
10,000.
Why? So 10,000 is the first going rate.
So he's a repeat offender. He
Okay.
doesn't seem to have any, he doesn't seem like a threat necessarily. The bird charge is suspicious. But because it's repeat, I wouldn't give him the 5, so I would jump to 10.
Okay. So you can tell from his criminal history, just looking at it on a piece of paper, he's an addict. He's stealing to take care of his drug habit, right? So 10,000, anyone else going once? It's like a Price is Right kind of thing, right? Anyone else want to take a shot? What you feel your gut's saying?
I'm happy with 10,000.
10,000?
50,000
50,000, why? Why 50?
because he has a lot of cases and he's not really learning.
Is he a danger to the community, you think?
No.
Okay,
He could be.
could be. Right, yeah,
I have a question. At
Yep.
this point,
yep.
obviously he needs consequences for his actions, but also where does the rehabilitation come in as well for him?
So the question is, where does consequences and rehabilitation come into this step? Nowhere for either question. So he's presumed to be innocent.
Right.
We're determining whether or not there's an appropriate aspect that he's going to show up to court and whether or not he's going to continue being a danger to the community. That's what the judge should be looking at. The judge isn't looking at it, how strong the case is, isn't looking at what's the possibility that he's going to be rehabilitated and we're going to kick him of his meth addict addiction. We're not even considering that he could be serving, a lot of time.
Where does he fall on the little list that you keep as far as did he show up to his previous court hearings for those?
Right now, you have no indication. He shows up. It's actually quite fascinating. In the world of COVID, complete side note, people actually are showing up to court far more now than they did in the past.
Funny.
It is. It's amazing that they can all zoom in to court proceedings in their beds without clothes, smoking a cigarette, doing whatever it is, driving down the road, but at least they're showing up to court. In the past, they always forgot about their court dates or they couldn't make it to court. So our FTAs have actually dropped drastically in the last 7 months. Yeah, it is. It's you would not think that, but it is. So Canyon County judge is probably going to, based on these facts, around 25,000. One of the strong indicators of flight risk would be because he's facing a potential life charge now, he might have more inclination to flee. That would be the biggest. And drugs are always deemed as a quasi impact and danger to the community, especially when you have a whole bunch of theft related. So our second case, right, Mateo is charged with a misdemeanor, domestic. They're at a barbecue, got angry, pushes his girlfriend. She scrapes her arm and bruisings her back. He's lived in Nampa for only 2 years. He works construction. He has 2 minor children with the alleged victim in this case. And you can see his criminal history. No felonies, but he does have a failure to appear in that aspect. What are you doing with a bond? What do you all say? Anyone want to take a shot?
I feel like it's gonna be less.
Yeah.
Okay, less. Okay,
And it's a misdemeanor, not.
okay.
Say $1 million.
But he does have the DUI and the fact that he was drinking again is concerning because that puts him at a greater danger to society.
Okay,
I would hit him hard before he gets worse.
but you're not punishing him at this stage. It's one of the big aspects. It's one of the big aspects, right, is you have to shut off the potential punishment component to this particular stage, which is why we're going through this exercise, right? So in Canyon County, based on these facts, and if you're working with the victim in this case, there's probably a really, really strong likelihood he's going to be released to like pretrial services and being monitored by the sheriff's office. He's probably not going to have to post a bond.
Why? That's so frustrating.
So, take the first guy,
Uh-huh.
take him,
Mhm.
now add in your lewd and lascivious charge that we have, maybe a couple bergs. And then the ultimate question, there's really a third factor in Canyon County that you're dealing with in Ada and everywhere else. You only have one bed space. Who do you put in there?
This
Yeah.
person.
You put him in versus the individual with the felony charge facing up to life.
For drugs though, I'd throw him into a rehab.
But with drugs, behavior is more erratic. So I can
Yep.
see why they would want to block the person that is
Yeah.
continuously on drugs.
Yeah.
I mean, I don't agree, no, but.
Now, do you put him, Mateo, in versus the other charge that's right after his, the guy that's molesting his 5-year-old?
Right,
Who do you put in?
Yeah,
These are the
not
challenges that we're
necessarily
dealing with
jail.
in the system. I'm not saying one's right, one's wrong. When I first started prosecution, this individual probably would have about a $10,000 bond. Now they're being released to pretrial because of spacing allocations, the ability to monitor.
So in
Uh,
Ada County,
Ada County's dealing with the same issues that we are because they have no jail space either.
so we would still be just probably ROR'd.
It's I'll tell you, when I first started, people would always do 2 to 5 days conviction on a DUI. Now, second DUI, you're lucky league to get that.
Why do they have to have a bed?
Because if they don't post their bond, we're obligated to house them.
Yeah.
Can we
And-
have a mat on the floor?
Yeah, we, sure, the previous sheriff, before
Sorry,
my
I'm sorry.
office became, because I wear 2 hats, right? Is I'm the chief law enforcement, the prosecutor that you think of and what we're talking about, but I'm also the chief civil counsel for all the 9 elected officials of the county. That's when the ACLU sues you because of jail conditions.
Yeah.
So you can't do that.
It's just hard because you think you.
Oh,
look at this
absolutely.
And you go, okay, so he's gonna go back to his girlfriend, convince her that it was her fault, she, or blame it on the alcohol. So then you lose that witness because he's gone back home to her.
I've heard of this concept called the cycle of
I
violence.
know.
Just go. Right? It's frustrating,
It's
Right.
so frustrating.
but it's important that you know this is
Sure.
what is happening. Is because you're working with that individual. They've gotten away from the previous night. Nampa PD, right, goes out to Mateo's house. He's arrested. He's sitting in jail potentially for a 24-hour cycle before he's brought before the judge on this particular situation. You have 24 hours to really work and cement with that victim. Because the odds that that individual is getting released is really, really strong. If it's a misdemeanor crime in the state of Idaho, unless they have an egregious history and maybe like 5, 6 failure to appears, the odds of them getting a bond, or if they do get a bond, it's going to be a fairly low bond, is really, right?
So does the criminal get educated on, he's got a no contact order, and that's
Yep,
obviously by law enforcement. He comes back to these women and say, you've got to drop this charge, you've got to drop this charge. Well, they can't.
No, because who's bringing the charge?
That's
The
what,
state of Idaho.
yeah.
So then,
Do they not know that? Are they not educated in jail now?
oh, please.
'Cause do
They
it
get some of the
all
best
the time.
they get some of the best education
do.
humanly possible at the jail in that 24-hour period of time of what to do and how to manipulate the victims even more. And it becomes, right, we're all in it together. I said it's a whole system, right?
Right.
Is if I'm the nervous system, you're trying to breathe life into this victim as the respiratory system, knowing that, hey, the central nervous system is stuttering over here. We better pump some more oxygen into this victim to get them out of the situation, which is why oftentimes it takes multiple times. Because the system, right, although this is really quick, and the preliminary hearing will be quick, the rest of the system, I mean, we haven't had a trial in 7 months. So we were, in September, we were 1,200 felony trials backlogged. Felony trials. And it's a matter of how do you process it? How does a victim that has to go back into the situation knowing that there's no end in sight? These are the challenges that we're dealing with, and I never thought I would see in the world of COVID, right? It's challenging, but when you're working with these individuals, know that the system is coming and the system is geared towards the defendant. And the victim, oftentimes, maybe this isn't the proper legal vernacular, gets screwed by the system in the way in which it's structured multiple times. Maybe hose is an appropriate term. Make sense? Oh, sorry. Let me go backwards. So, once that individual, so go back to our hypothetical, the next step in the process is the preliminary hearing. So by the time that they are arrested to the time that they have this hearing has to be within 14 days. So it's a very quick process. Sometimes you can have the victim, you haven't put them back into the honeymoon phase, right? Within this 14 days, which is why we try to move these cases very quickly. This is typically a public hearing. It's a mini trial, as I like to call it. Is if, take for example, so what happens at this trial? We'll go here first is the magistrate judge, the magistrate judge is present, the prosecutor, the defendant, the defense attorney are present, and the prosecutor has to prove at this hearing that probable cause. If there's 51% likely that a crime of domestic violence, domestic battery has occurred, and this is the person that did it. Now we'll have to put on witnesses. Oftentimes the victim comes and has to testify at this hearing, and then is subject to cross-examination by the defense attorney. I call these little miniature trials, as a lot of the same rules apply as you would see in a jury trial, but they're a lot shorter. As think of it, the best example would be is for a felony domestic trial, to go to hearing or to go to trial is probably going to take 2 to 3 days. I can probably run a felony domestic preliminary hearing in about 20 to 30 minutes. So a lot of the formality process is eliminated and we can expedite it, but everyone is subject and the victim has to see their accuser right then and be cross-examined by the defense attorney at that time. And the ultimate end is the judge can determine one of two things. Judge isn't determining guilt or anything to that effect. The judge is merely saying there's no probable cause, so the case has to stop in the system. This is really, you think about, this is our fourth check on probable cause. So this is a separate judge and the first one that did the arraignment. And, or there is probable cause. And if there's probable cause found, then remember that document I said it's called a complaint. A new document is now issued, which is identical to the complaint, but the word complaint changes and the word information is inserted. But they look the same. And all it is, once again, it's all the English system, is the lower court, the magistrate, is informing a higher court that there's sufficient probable cause for this case to continue on through the system. That's all it is, but the formal charging document changes. And then they go to another arraignment. Does that make sense? This is a very fast process from the time of arrest to the time of the preliminary hearing, typically 14 days in our system. Now, everything's geared to the defendant. So the defendant can waive their right to this hearing, or they can force the state to make the determination. Usually plea bargaining has already started on day one. We're trying to resolve the case at that stage, working with the victim, potentially, right? Hey, plead to the misdemeanor domestic instead of the felony domestic, or the defendant can continue it. So everything is geared towards the protection of the defendant. So that was route one, the preliminary hearing. In Canyon County, this is probably 90% of the cases go through this route. It's a much more efficient and fast process. We like to get it. Oh, my thing's not working. Or you can go through route two. So go back, right? A crime has been committed. The police have submitted that case now to the prosecutor, and the prosecutor makes the determination of what we want to do. You'll see the grand jury route. oftentimes for the people, the individuals that you're going to be working with is a lot of your sex crimes cases. So they take more time to develop. You can't, there's no need to arrest right away, but you send them to a grand jury, which a grand jury just consists of 12 to 16 normal jurors. So when you get your jury notice from the Kane County Jury Commissioner, you have no clue what type of jury duty you're going to be doing. You could be called, and then once you arrive, you could go, oh, this is grand jury duty. But it's super secret court, is what I like to call it. It's like Fight Club. What happens at grand jury, you can't talk about what happens at grand jury. You're not even supposed to tell people you're a grand juror, right? Is if you tell anyone of what transpires in grand jury, it's a felony offense in the state of Idaho. And the only individuals at super secret court is going to be your grand jurors, the prosecutor, and the witness. A little different than the preliminary hearing. There's no judge. There's no defendant. There's no defense attorney. Is the grand jurors are doing the exact same thing as that magistrate judge was doing. Is there probable cause? 51% likely. Or no probable cause. If they decide that there's probable cause, more likely than not, then they issue an official document called an indictment. So if you see a document of a complaint or an information, you know that's gone through Route 1. If you hear that an indictment has come down, then you know it's gone through Route 2. Typically in Kane County, we run 3 types of cases through our grand jurors. Our sex cases, because it's much easier for 5-year-old Susie, not that it's easy, it's easier, to testify with just the prosecutor and the grand jurors than to sit in a public forum where the media could be there, but the person that's perpetrating is there and the defense attorney to question them. The other type of cases we run through are like narcotics cases where you have confidential informants or undercover officers, because it's super secret. You can't know what's who's there until later on in the process. And our third type is we do a lot of gang cases through grand jury because of the fear of retaliation and knowing snitches get stitches, all that kind of stuff, right? So that's typically what goes on through grand jury. So, whoa. Look at, I'm trying to confuse you. Now, okay, so this is where we're at. The crime. We have to make a decision of whether or not to charge or not charge. If we say no, the case doesn't move through the system. If we're going to charge, we have to decide which route we're going to go down. The first path is if we issue a complaint, we go through that initial arraignment. We then go to a preliminary hearing, the information is filed, and then we move to the next stage, which we'll talk about here just briefly, is the district court arraignment. Or the prosecutor can make the decision that we're going to go through Route 2, which is the grand jury process. And then if a grand jury says yay, of probable cause, then they've indicted the individual. And they both ultimately end up at this district court arraignment. This is in the felony process. Does that make sense? If you're to look at the misdemeanor, you take out the preliminary hearing, the grand jury, and the district court arraignment. And then the rest of the process is the same. Questions up to this stage? Comments, thoughts, concerns? Anything? No? Okay. So the district court arraignment is the first time in the felony process that the defendant has the opportunity to plead guilty. So the state of Idaho is a very simple state, which is why I like it. And I'm a native Idahoan. But you only have 2 choices in Idaho. You can either plead guilty or plead not guilty. It's very simple, right? One or the other. Yeah, there's none of these like California. There's like 6 different types of pleas. Now, Idaho, you get one or the other. There's a guilty plea or a not guilty plea, which I really appreciate. The individual is given all the exact same rights that they were at this initial arraignment. So it's like a duplication. If you've gone through Route 1, you get to hear it for the first time in route 2. Okay, make sense? Okay. So then 99% of the people plead not guilty with the district court arraignment. It's like the biggest, we're being recorded. I have to be careful. It's probably one of the most inefficient hearings that there is in the criminal justice system. Sometimes it just is a matter of procedural due course. Because changing your plea, if you ultimately want to change your plea, it's a very long litany that the judges go through, right? It's like a 30-minute discourse. You realize what you're doing, you realize the punishments, or you have sound mind, you read and speak the English language, you know the immigration consequences. They go through this litany over and over and over and just beat into the defendant to make sure they really know what they're doing of what's going to happen. So most of the district court arraignments are very quick because they don't want to drag the process. So they set those change of pleas for a specific time. But those that say no, we can then go to what is referred to as the pretrial hearings. This is probably where all the, it's not probably, this is where the vast majority of the criminal justice system takes place, is at this stage, is the pretrial hearings. And there can be multiple pretrial hearings within one particular case. That's why it's in the plural. But what typically happens, the big thing that happens here is where the plea bargaining takes place. So in the criminal justice system, I was reading an article about a year ago. I don't know if it's changed because of COVID or not, but it indicated that 95% of all cases in the criminal justice system are resolved via plea bargaining. And there's basically two types of pleas, right? There's what is referred to as sentencing pleas and charging pleas. So the sentencing plea is we've negotiated what the appropriate sentence should be before we even present it to the judge. So both sides have agreed, hey, this is a probation case, or this is amount of prison time, something to that effect. That's what we refer to as you're already deciding what type of punishment is appropriate before you present it to the judge. The charging would be dealing with the appropriate charges, right? Is, hey, this is a second-degree murder case. You plead to voluntary manslaughter, so you're modifying the type of charge. Or, hey, you have 15 grand theft charges. You plead to 5, we'll dismiss 10. So you're negotiating the charges, either the type of charge or the number of charges. So those would happen, but 95% of all the cases are resolved in the plea negotiation. So think about it as 95 individuals that you work with in this center in which cases are going are likely never going to have to go to the trial phase. And the article that I was reading said if that dropped by about 5%, the entire system would collapse because there's not enough resources to do that. So it's a necessary evil in the system. And once again, this is where we're weighing the strengths, weaknesses, my office, law enforcement, the center, right? You only have so many resources available too, right? So think of it, and if I doubled, that would be 5% more Jenny's subpoenas. Would you even have time to do client intakes? You wouldn't, right? The center would then have to hire, in a sense, a second person to just cover yours because you're testifying the whole time. Does that make sense of how this works? And same thing with law enforcement is we only have budgets, right? And not to say that money is the end all, but you only have so many people, bodies, resources. You know, when it takes 80 to 100 jurors to sit for a trial to pick 12 of them, you start changing those numbers, that changes a whole bunch too, right? We calculated is if every one of our 1,200 felony trials went, that would be approximately 38,000 to 40,000 jurors. That's more people than voted in the last election in Canyon County. So we probably don't even have the appropriate jury pool to do it. So you just start seeing everything. People get frustrated with plea bargaining, but it's a necessary aspect. And right, it's you'd rather know what you're going to get, both sides. It's this compromise versus the unknown, right? It's like O.J. Simpson, right? You don't know what's gonna happen. It doesn't matter what 350 million people think that OJ killed his wife. It only matters what 12, right? Not that day. So typically, and then a whole bunch of motions. So when then we're deciding, these are evidentiary issues of what evidence can be brought, what evidence has to be excluded. All these things are taking place. This is where all the attorneys are doing their attorney stuff, the defense attorney and the prosecutor. And typically one of two things happen. Is either they plead guilty or they go to the not guilty phase, which is ultimately the trial. They go plead guilty and then we go to sentencing, which we'll talk about. Up to this point, questions? We've been going. Do you need a break or are you good to go?
Is pleading guilty common?
Yeah, 95% of the cases are resolved, usually in some type of guilty plea.
Do they get less consequences for admitting their guilt?
Not necessarily. Sometimes they do. This was pre-COVID. We had a trial. We offered an individual what's called a retained jurisdiction, which I'll explain. So it's like an in between prison and probation. The guy said no. We went to trial. He was found guilty and the judge gave him probation. So he actually got a better deal by going to trial. Now, there are some judges that say, you go to trial, I'm just maxing you. So it's a crapshoot.
Right.
When it comes to what the sentence is, because then all options are on the table. Typically, yeah.
Is this
Go
where
ahead.
they would do?
Go ahead.
Is this where they would do an Alfred plea?
This is where they would do an Alfred plea if they so choose. So all an Alfred plea is, and don't get confused in the world of Alfreds, it's still a guilty plea in Idaho. So you have to still plead guilty. So all an Alfred plea is, it's based off of a Supreme Court case, North Carolina versus Alfred, that says, I'm taking the plea agreement in order not to go to trial, because I think the state has enough evidence to convict me. I'm not gonna say I'm really guilty, but I acknowledge that it's still a plea of guilt. It's a legal technical loophole that makes the defendant feel better. But all it is a guilty plea in the state of Idaho. We recognize it as a guilty plea, and that's what it is. On criminal histories, convictions, using it against them down the road, it's a guilty plea. So I wouldn't get so confused on an Alfred plea. It's just a legal technical loophole. Does that answer your question?
Yes.
Okay. Questions up to this stage? You guys need a break? Are you good to go? Chug along? That's the way I like it. Okay. So this is kind of where we're at up to this stage. Our crime of domestic battery comes in. We decide yay. We then decide which path. Typically, we go through the arraignment, the prelim, the district court arraignment. If they want to take that plea agreement, then we'll go to sentencing. If not, we see if we can resolve it at the pretrial conference, see what evidence the judge will let us use, what not use. The judge typically rules in the prosecution favor. Guilty pleas usually end up. If the judge puts the smackdown on us, or for whatever reason, the defendant just doesn't want to plead, then the not guilty is still put in, and then we end up going to trial at this stage. And trial is probably the most visible section of the criminal justice process, right? Because that's what you see all the movies and stuff on. So the sexy part, which we'll talk about that. So questions, comments up to this stage, and then we're going to dissect how a trial works.
The financial aspect
Mhm.
for the person convicted, are they responsible for paying for if they choose to go to trial, if they're sticking with the not guilty plea? Is that one of the drawbacks to going to trial? Or is
Yes.
it just like biting the bullet and saying I did it?
Yeah. So the question is does the individual have to pay more for trial if they have a public defender? Well, if they have a private attorney, yes, they're paying a lot more. If they have a public defender, Typically, the courts assess a trial fee as well, but you have to remember, most of these individuals aren't going to pay any of this money back. And the county is not going to ultimately try to collect. I think we have something around like $30 million in outstanding court fines and fees. Because sometimes it's squeezing blood from a turnip in that aspect there. I mean, yeah, most of them aren't going to be super affluent to afford it anyway, right? Does that make sense? So I wouldn't say that's a primary deterrent to do it. They're not really thinking of that, and would be my gut instinct. So this is what a typical courtroom looks like, right? These are the characters that you will see. So if you go to a trial and you're working with the survivor, you'll typically see the judge, right? Person in the black robe. The court clerk, I would say, this is the person that really runs the whole courtroom. They are amazing. They keep the judge on track, the attorneys on track, but they often get just pushed to the side. But they're the ones that really run everything. You always have the bailiff, court security, right, in that aspect. You have the jury box. For felonies in Idaho, it's 12 individuals. Depending on the serious nature, they might have a couple alternates. And a misdemeanor, it's 6 individuals, right? Then you always have the defense attorney and the prosecution. And then you would be able to sit in the audience section. If you're ever on Jeopardy, this railing is referred to as the bar, which is why we have to, as attorneys, you have to pass the bar exam. In order to go into the well and to pass the bar, that's what you have to do. Otherwise, no one else is allowed to go in there. So Jeopardy knowledge for you, right? So that's why we're called barristers and everything in that aspect, right? Is we pass the bar. So, right. So if you graduate law school, you're not a licensed attorney, you can't go beyond the bar. Okay, so here's the structure of a jury trial, right? So the first stage, I often say, is probably the most important, and it's often the most overlooked stage, and that is the fancy called for dire, but it is the jury selection process. That's when your 80 to 100 individuals come into town, in the courthouse, and then we're trying to decide who the 12 individuals that are most appropriate to sit on this particular trial. So you typically are pulling people from DMV, voter registration, individuals such as that, but it can be anyone and everyone. And every case is different of who we think is going to be the most appropriate individual for trial. Make sense?
Yeah, can you volunteer for a jury duty?
No. You're a volunteer for you. Yeah. Because most people that want to serve on jury duty are usually the ones that are kicked off. So it's very interesting. It's very, yeah. Jury selection is a very fascinating. There's a lot of psychology. You're trying to figure out who resonates the best with you, right?
So who determines who gets to be on the jury?
The defense attorney and the prosecutor.
So they each get picked, or?
No, we are deciding who is getting kicked off, and then whoever is left is the 12. So we each have what is, not to go too detailed into it, so we have what is referred to as peremptory challenges. So once again, depending on the nature of the crime, the judge will lock, so say, I have 3 strikes, I can just get rid of somebody, the defense attorney has 3. But we can also excuse individuals, what is called for cause. So let's say one juror, that's our domestic battery case, one juror is a survivor of domestic violence, works at a domestic violence shelter, despises every single individual that has ever committed domestic battery and wants to see them hang from a tree. Let's just say that person exists and they got selected for jury duty for that particular case. What would transpire is the judge is going to say, person, juror 1, can you truly be fair in this particular case? Of course I can, Judge. The judge will then kick them off. So my wife, for example, got selected for jury duty last year. And she gets put into the box. She's in the group of 80. And one of my deputies knows her. Right? And the judge, the defense attorney doesn't know so much who she is until the judge says, hey, do you know anyone on this trial? She raises her hand. Who do you know? Well, my husband is her boss, right? And I'm the named party to the complaint. And the judge says, are you sure you can be fair and impartial in this particular? And my wife is, she'll hit me if I say this. She's very well trained. Of course, Judge, I can be neutral and impartial. I make the rules at the house. Anyway, and the judge kicked her off in that aspect. So, for example, I could never get selected because I would be impartial. I could get summoned for jury duty, and then I would get kicked off. Does that make sense?
Yep.
So,
Do you have, I mean,
Yeah.
if somebody asked that survivor, for example, I would think that her honest answer would be, no, I can't be impartial. or
yeah,
fair."
and that's what,
So can you,
absolutely, you can say that. Most people will say something that intentionally tries to get them kicked off, which is a very frustrating aspect, right? Because a lot of people don't want to do jury duty. It's I would say is the two things as we as citizens of this country need to do. We need to vote, and we should be willing to do jury duty. Jury duty sucks. It's long, it's arduous, but it's part of our civic duty if our system is to operate the way that it should. But a lot of people will say that, right? It's, you have the individual that her son was killed by a drunk driver. She may be completely perfect on the domestic violence case, but she is probably not appropriate on the DUI case. Does that make, so you're asking a whole bunch of invasive questions of all these individuals and their life histories of whether or not they can be fair and impartial, which is the ultimate determination that we're trying to make for each individual. Right?
In the jury selection I was a part of, they asked if anyone knew the arresting officer.
Yep.
Like they went as far to.
Absolutely. Because once again, do you know any of the players involved? So the judge usually reads all potential witnesses that are going to be testifying as, hey, the officer could be your next door neighbor and your BFS, but you didn't know that going into it. So likely you're not going to be fair and impartial. You're going to side with the officer's testimony. You're going to automatically give them credibility versus, make sense? So you never know who you're going to get for jury duty, right? Which is,
Everyone, guess what? I have been selected. For what? Oh, nothing too important, just jury duty. They have summoned me. I am part of an elite group of individuals deemed intelligent enough to decide the fate of a fellow citizen. The amused laughter of the envious. They don't just pick anybody for this job. Yeah, they do. Bryan, perhaps I have not made myself clear. I have been entrusted to pass judgment upon others. Everybody gets called for jury duty, you stupid idiot. I've been called. The only reason you've never been called is that they use the voter registration list, and this past election is the first time you ever voted. I voted before. I stuffed the ballot box at the Oscars.
so you never know who you're going to get in the world of jury duty, right? So, but the first stage is the jurors come in. Both sides are trying to select who those 12 people that are going to sit in judgment of the defendant. It's not the judge that makes it. It's not the prosecutor. It's the 12 individuals. So the next stage here is it's the prosecution, the state of Idaho, that's bringing the charge. So we always get the first word. So the state always gets to go first in every trial. And all the opening statement is I'm going to present to these 12 individuals what we anticipate the evidence is going to be. It's not an argument. We're just laying out. This is usually a chronological approach is on this date at this time, officer so-and-so went to this house. There he met the victim. The victim conveyed that she was beat by this particular individual. She suffered a black and blue eye. You're going to hear from a doctor that's going to say that it caused some brain swelling and to that effect. And ultimately, at the end, we're going to be asking you to convict this individual. Much more elaborate and more theatrical in that aspect, but that's basically what it is. And then after I give my opening statement, the defense has their opportunity to make that same opening statement, but in favor of their client. right? So then they present, yeah, that's not what the facts are gonna show. This is what you're gonna really hear from all these witnesses. So as long as you're doing it in good faith, what you believe is gonna be, and that's where all those pretrial motions is, we've already determined what type of evidence is gonna be coming in, what's not gonna be coming in by the time we're crafting this statement. So this is a classic example of what a prosecutor's opening statement looks like, and then followed by a defense attorney's opening statement. Everything you can learn about the court process, you can learn from Hollywood. So. This is from my cousin Vinny.
Your Honor, counsel, members of the jury, the evidence in this case is going to show that at 9:30 in the morning of January 4th, both defendants, Stanley Rothenstein and William Gambini, were seen getting out of their metallic green 1964 Buick Skylark convertible with a white top. The evidence is going to show that they were seen entering the Sack and Suds convenience store in Wazoo City. The evidence is going to show that minutes after they entered the Sack and Suds, a gunshot was heard by 3 eyewitnesses. You're going to then hear the testimony of the 3 eyewitnesses who saw the defendants running out of the Sack and Suds a moment after the shots were heard, getting into their faded metallic green 1964 Buick Skylark and driving off in great haste. Finally, the state is going to prove that the defendants, Gambini and Rothenstein, admitted, then recanted their testimony to the sheriff of Beecham County. Now let's get down to it. Your verdict is going to depend on what you think of the sworn testimony. Not what I think. What I think don't count. You're the jury. It's your job to decide who's telling the truth. Truth. That's what verdict means. So here it comes down from old England and all our little old ancestors. Now, we're going to be asking you to return the verdict of murder in the first degree for William Gambini, and a verdict of accessory to murder in the first degree for Stanley Rothenstein, for helping Gambini commit this heinous crime. Counselor, if you wish to make an open statement. Counselor. All right, it's time to make the open statement. Come on, man. Let's go. Everything that guy just said is bullshit. Objection, Your Honor. Counsel's entire opening statement is argued. Objection sustained. The entire open statement, with the exception of thank you, will be stricken from the record. The jury will please disregard counsel's entire open statement.
So the prosecutor sets forth what he believes is going to be in that aspect, right? The homicide that Mr. Gambini had committed. So doesn't argue, but just gives the facts. Whereas Joe Pesci, right, Vinny, makes the argument. And you can't make an argument at the opening statement in that aspect. So, but that's basically, we're trying to tell our side of the story that the jurors are going to hear. So this is really one of the first times that they really get to start hearing what the case is all about. So then the next stage is really the meat and potatoes of the trial. So this is where the state and the defense presents their cases. So once again, the prosecution always goes first. We usually have the majority of the witnesses because it's our burden, and that burden is beyond a reasonable doubt this crime's been committed. So we're the one that is going to present usually almost all the witnesses in the trial. And the typical stage in this, where you see this green box saying stage 3, this is the typical format, both for the prosecution and the defense, right? Is whoever calls the witness has what's called a direct examination. So it is always open-ended questions. So for example, What is your name? So that's an open-ended question, right? What is your name? Whereas a cross-examination is all closed-ended. Your name is Tanya, correct?
Yes.
Where you're soliciting just yes and no questions. So that's the difference between a direct examination and a cross-examination. Make sense? So for the prosecutor, we just start asking who, what, when, where, why, hows, and let the witness tell the story. The defense attorney on the cross-examination is going to make sure the questions are much more close-ended, more yes, no's. So basically asking them questions to which you already know the answer to in that aspect, not letting them elaborate. So after I ask them who, what, when, where, whys, the defense asks their yes, no's, I can then ask questions of what the defense attorney asked. And then the defense attorney can ask about questions in which I just asked on this redirect. And that can keep going back and forth to infinity if you so choose. But that's the way in which this process, and this happens for every single witness. So the victim of these cases, right, typically 9 times out of 10, the victim is usually a prosecution witness, unless they're so hostile to us that we may not want to call them. But typically, I'm the one that's going to be working with this individual, and we're going to get them ready to what it's going to be like to be cross-examined, right? Does that make sense? And then after I'm done with all my witnesses, I do all my witnesses first and present all my evidence. It's only until I'm done and you hear this terminology as the prosecution rests their case, meaning I believe I have proven that this person did it by 95% likely that they committed the crime beyond reasonable doubt. Only until then will I close my case, and only until then does the defense get to present sort of their defense, if they so choose. Sometimes they don't present a single witness at times because it's all on my burden. The defendant doesn't have to testify either. Make sense? Questions, comments, thoughts? So I'm going to show you, this is a classic example of a direct followed by a cross and then a redirect, recross. And this is actually going to be a defense witness. So the prosecution has already presented their whole case, and now the defense attorney is going to present his first or one of his witnesses.
Corporal Jeffrey Owen Barnes, Marine Barracks Windward, Guantanamo Bay, Cuba.
Corporal Barnes needs some reasons why a Marine received code red.
Being late.
So open-ended, right?
Company meetings, keeping his barracks in disorder, falling back on a run.
Have you ever received code red?
Yes, sir. We were doing 7-man assault drills and my weapon slipped. It was just because it was over 100 degrees and my palms were sweaty and I'd forgotten to use the resin.
What happened?
That night, the guys in my squad threw a blanket over me. Took turns punching me in the arm for 5 minutes. Then they poured glue on my hands. And it worked too, because I had never dropped my weapon since.
Has Private Santiago ever late for 2 meetings?
Yes, sir.
Has his barracks ever disordered?
Yes, sir.
Did he ever fall back on a run?
All the time, sir.
Did he ever, prior to the night of September 6th, receive a code red?
No, sir.
Never?
No, sir.
You got a code red because your palms were sweaty. Why didn't Santiago, this burden to his unit, ever get one?
Dawson wouldn't allow it, sir.
Dawson wouldn't. No.
The guys talked tough about Santiago, but they wouldn't go near him. They were too afraid of Dawson, sir.
Object. The witness is speculating. I'll rephrase. Jeffrey, did you ever want to give Santiago a code red?
Yes, sir.
Why didn't you?
Because Dawson would kick my butt, sir.
Captain Ross can ask you some
So now the prosecution is going to cross-examine.
Corporal Barnes.
I hold here the Marine Outline for Recruit Training. Are you familiar with this book?
Yes, sir.
Have you read it?
Yes, sir.
Good. Would you turn to the chapter that deals with code reds, please?
Sir?
Just flip to the page of the book that discusses code reds.
Well, you see, sir, code red is a term that we use. I mean, just down to Gitmo. I don't know.
Oh, we're looking at it.
Standard operating procedure, right to security company, Guantanamo Bay, Cuba. Now, I assume we'll find the term code red in its definition in that book. Am I correct? No, sir. No? Corporal Barnes, I'm a Marine. Is there no book, no manual or pamphlet, no set of orders or regulations that lets me know that as a Marine, one of my duties is to perform code reds? No, sir. No book, sir. No further questions.
Now comes the redirect. Based on that.
Would you turn the page in this book that says where the mess hall is?
Lieutenant Cappy, that's not in the book, sir.
You mean to say all your time to get one? Never had a meal?
No, sir. 3 squares a day, sir.
I don't understand. How did you know where the mess hall was if it's not in this book?
Well, I guess I just followed the crowd at chow time, sir.
No more questions.
Couple Barnes, you messed up that.
Thank you, sir.
So that's how, right? That's how a direct examination, cross-examination would work. And it doesn't matter whose witness it is. Whoever's witness it does always goes first with the direct. And then the opposing side does a cross-examination. This is the bulk and the meat and potatoes of a trial, what takes the most. So the voir dire usually is 2 to 3 hours for a felony domestic. The opening statements are probably no more than 30 minutes to an hour at the most combined. And then the next couple days are the witnesses, because it takes time, depending on what people say on the witness stand, right? You never know what they're going to say. You should know what they're going to say, but trust me, you'll be surprised. So then, after all the witnesses, all the evidence takes place, right? We submitted the photos, the doctors have testified, the victims testified. The defendant, if he so chose, he can testify. He doesn't have to, though, right? It's a Fifth Amendment privilege. And all that information, all the physical, the photographs, everything else, once it's all done, then we make our final pitch to the jury. These are the arguments. Now we're arguing everything that you've heard, seen, experienced. This is why, basically, the prosecution, why you should find him guilty of our felony domestic. The defense is going to say, no, 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 no. You heard things wrong, Mr. Taylor. This is why you should find him not guilty, right? These are basically the two arguments based on our view of what is heard, saw, and experienced, right? Everyone's going to have two different opinions. That's why it goes to trial, right? So the prosecution goes first, then the defense goes. They get to make their closing statement. And then, things not working, the state gets the final word. So we get to go first, and we get to say the last word before it all happens. Make sense? So I'm going to show you an example. This is actually a defense's closing argument. So the prosecution has already given their argument. The defense is now going to give an argument of why his client shouldn't be charged with the crimes. And basically, he's summarizing what he heard from the evidence, so you'll be able to capture.
A dark street, a stormy night, 2 desperate men struggle. One man is taken to the hospital, the other one goes to jail. The prosecutor wants you to believe this is an open and shut case. A poor man brutally victimized. Oh, for once I agree with the prosecutor. This is an open and shut case. But the true victim is my client. Yes, you heard me right. Put yourself in his shoes for a moment. You're walking from church alone in one of the toughest parts of the suburbs. You're nervous, timid, looking over your shoulder when suddenly you encounter him. Bouncing from the shadows. The streetlight flashes on something shiny in his hand. No time to think. And in that terrifying instant, you do what any respectable citizen would. You defend yourself. Only after you've shattered his arm and collarbone do you realize it's all a mistake. The man was merely walking away from an ATM machine. The apparent flash of metal caused by his bank card. And as you stand over his crumpled, yet potentially still dangerous form, your heart goes out to him. You want to help. First, you gather up the many bills he dropped to stop them from blowing away. Second, in an effort to find someone to notify, you take his wallet, fully intending to return it. Then you leap into the man's Lexus to head for assistance when suddenly a police car speeds up. Well, you breathe a sigh of relief. Oh, joy! Help has finally arrived! Do the police applaud your initiative? Do they praise you for your heroism? No. You're thrown to the ground, forcibly cuffed, and your rights are not read to you, but shouted at you in a very hostile tone. You have the right to remain silent. Now ask yourself, at this point, do you have any choice but to shout blindly at your attacker? Woman or no woman, you put those guns on, you become a threat, baby! A loose cannon! And quite possibly, from my client's perspective, the deadly enforcer of a police state. No wonder people are so afraid to reach out and help each other. I don't want to get involved. That's what they say. My client tried. And what did he get? All of this.
Like I said, you can get two different perspectives in a closing argument. You don't know what's going to happen, but that's what takes place. And then the state, the prosecutor, would have the ability to rebut that particular statement in a normal trial. So then the last thing that happens after we've made our arguments, the case goes back to the 12 individuals. And then those 12 individuals in the state of Idaho have to make a unanimous decision whether or not this person is guilty or not guilty. So all 12 have to come to an agreement, right? And once again, we'll watch one more clip here. This is 12 Angry Men, the original. So they're casting their ballots here of what to do.
Guilty. 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 Not guilty. It's guilty. Boy, how do you like that? Oh, another chap flips his wings. All right. Who was it? Come on, I want to know. Excuse me. This was a secret ballot. We all agreed on that, no? If the gentleman wanted to remain secret. Secret? What do you mean secret? There are no secrets in a jury room. I know who it was. Brother, you really are something. You sit here both guilty like the rest of us, and some golden voiced preacher starts tearing your poor heart out about some underprivileged kid just couldn't help becoming a murderer, and you change your vote. If that isn't the most sickening. Why don't you drop a quarter in this collection box? Oh, now just wait a minute. Listen, you can't talk to me like that. No, who do you think you are? Calm down. It doesn't matter. He's very excitable. Sit down. Excitable? You bet I'm excitable. We're trying to put a guilty man in the chair where he belongs. Someone starts telling us fairy tales and we're listening. What made you change your vote? He didn't change his vote. I didn't. Oh, fine. You make me tell you why? No, I would like you to tell me why. Well, I'd like to make it clear anyway, if you don't mind. We have to listen to this. Man wants to talk.
So you never know. It's a great movie if you ever get a chance. Basically, it is this entire last stage, right? The jury deliberation. And it goes from 11 to guilty and 1 not guilty to the other way around. The guy's ultimately acquitted, right? In that aspect. So in our system, you have one of 3 things that a jury can do. If all 12 say guilty, he's found guilty in our hypothetical of the domestic. If they say not guilty, it's the fancy legal term called an acquittal. If you ever see the term acquittal come up, you know they've gone through the whole process. Versus just not guilty or a case dismissed, that could have happened any part of the entire system. Acquittal only comes from a jury. Or it's a hung jury. So meaning 11-1, meaning a unanimous decision of all 12, either on the first two things, didn't take place. And if that, you basically start from the district court arraignment and start the whole process over until you get another jury. Sometimes we expedite it, usually we expedite it, but you start off with a whole new jury and you go round 2. So.
Has that happened to you before?
Oh, many times.
Really?
Yeah.
How do you feel about that?
Yeah, it's frustrating. It's a lot of time and energy. Both sides are frustrated with it. So, but it depends, right? Is then you usually poll the jurors. And if it's 11-1 for guilt, that means you got a rogue juror for whatever reason. And then the case usually is pled guilty. If it is 1 for guilty, 11 not guilty, it's usually an indicator for me, don't take this case to trial. So we can kind of get a pulse of what was happening. But no, I've had one where it took us 3 trials to get it. So 2 different hung juries. And then we got the conviction.
Wow.
So, so if they're found guilty or they pled guilty, any part, remember one of the stages was then you go to sentencing. So Idaho, what typically happens is they get what's called a PSI or a pre-sentence investigation. And this is basically the whole life story of this person. It goes from basically when they were born to their schooling years, to their drug usages, to education, family history, abuse, everything and in between. So they're very thick packets of information. Basically what the investigation is it's trying to give the judge as much information to make an informed decision of what is appropriate sentence. In Idaho, once again, 3 options are usually available to the judge. And you can mix and match these in any aspect. One is you're put on probation. So that means, hey, you have redeemable qualities. We're going to help you rehabilitate. This is where your rehabilitation starts to come in. You're going to be working with a probation and parole officer on your domestic violence classes. Maybe the no contact order stays in effect for a while. You're going to have to stay clean. You're going to have to go get your GED, whatever those conditions and terms are. And we're going to put, this is a certain amount of time for you to succeed and be a reintegrated, positive member of community and society.
Is that drug court too?
It could be, yep, all the, especially drug court, mental health court, veterans court, DUI court, whatever it is, yeah. All the specialty courts would be a term of probation. And what typically happens is the judge hangs prison time over this person's head, right? The other big option is you're going to the big house. You're heading down to south of Boise and you're not going to go on an airplane, right? You're going to go down to the state pen and you're going to go there for a period of time because I don't see any redeemable qualities in you and your actions deserve punishment, which is the other metrics that we're trying to balance. And then you're going to go to prison for an allotted amount of time within our system. So you'll often hear, I don't have a visual on this, but you'll hear that Idaho has our sentences are what the sentences are, which is nice. Unlike some states, you never know what you're actually going to get. So if this person gets convicted of a domestic battery and the judge says, you have 2 years fixed plus 3 years indeterminate for a total of 5 years. If you're going to prison, that means you have to do an absolute minimum of 2 years. And after 2 years, the parole commission then makes the determination if you're going to do any more of that 3 years, you could do 1 of those 3 years, or you could be released out on parole. The judge on probation can still say 2 plus 3, but I'm suspending all that time. So you'll see that, still see that underlying sentence, But you don't have to do any of that 2 years unless you mess up on probation. The main difference between probation and prison is in the world of probation, the district judge still has control over this person's life. Once they go to prison, the judge has given up control, and now it is up to the parole commission what to do. And the parole commissioner are individuals that are appointed by the governor to decide what to do or not do. Does that make sense between the two? And then there's a middle one. You probably have heard it. It's an acronym called a rider or retained jurisdiction. I like to think of a rider program as it's an adult timeout. Right? It is the judge is going, this is really tough with all this information. I don't know if it's appropriate for you to be on probation because you've got rehabilitative skills, or I should just send you to prison. So what I'm going to do is I'm going to send you to adult timeout for about a year. You're going to go up to Cottonwood. You're going to get a whole bunch of treatment and training to see if you can come back and be a positive member of society. And if you can prove to me after this year that you can, then I'm going to put you on probation. If you can't even do this program and do all the treatment that I told you for a year, then clearly you're not rehabilitative, whatever that word is, and you're going to prison. So it's really an adult timeout to assess the situation of this particular individual. Does that make sense?
Yeah.
How those three work?
So when someone might say that they're on a rider, does that mean that they failed at the rehabilitation part, so now
Nope.
they're,
Well, it could.
okay.
They could have started on probation. They failed on probation. They got violated, brought before the judge. The judge could say, well, I want to put you back on probation. So they'd love to get second, third, fourth, fifth, sixth chances. Or I think I need to send you to adult timeout because clearly this probation world is not working. But I still don't think why you violated probation is so bad that I should send you to prison. You just need a more structured life. Because once you go on a rider, you're not free to go anywhere. It's a penal system. But the judge isn't giving that person's life and control to the parole commission. The judge is still keeping control for themselves. Does that answer your question? So the answer is possibly, but it could be another reason. Usually you're doing a rider because you can't handle probation and we need to give you more structured life.
Can I ask you how you feel that works? How do you feel that the system works there? Is that a bad question?
Yeah, it's a very bad question. It's a bad question. I think it works for some people depending on the nature of the charge. Other type of people, I think probation, the probation system and parole system is so overwhelmed right now that it's very difficult to give the adequate resources and time and attention, which is, I think, the whole system right now is hurting in that aspect. The rider is when you're working with your clients, if somebody gets placed on a rider, that kind of sends an indication to you, you have a year to work with this victim because this person's not going to have contact with them. You have a year to work with them to break the cycle. Because more likely than not, 90% of the people that go on a rider are released on probation, right? The last desired place to put somebody is in prison. That's the way the Idaho Supreme Court, the state legislature, everyone has pushed the system. We don't want to incarcerate people. And that's a debate that we could have of societal, does penal incarceration work, doesn't work? I'm not even going to get into the politics of that aspect, but that's the approach of it right now.
So when they're in, I'm sorry, Crystal, go ahead.
That's okay. So if they're in the rider program and they fail the rider program, do they come back to the judge?
Yep,
And
then the judge gets a report that they failed the rider program, then the judge says, you're going to the big house typically. Unless the judge is really nice that day. Yeah, even though you failed, the judge still has the authority to put them on probation, because that's what the judge gets to
So
do.
if they complete a rider, does the other years get wiped? Like,
Yep, so if that 2 + 5, that would be 1 year off of that mandatory minimum.
But they can get released onto probation and then there's no threat of going to prison
Yep,
after the.
yep, there is still that threat. So think of it as, I'm gonna use the example, the 2 + 3, right? 2 years fixed, 3 years indeterminate equals a 5-year sentence. So everyone's on that. So if you do your rider, now it basically, you take 1 year off of those 2 years.
Okay.
So now it's basically a 1 + 3 that's hanging over the person's head.
Okay.
So there's a possibility of 4 years of prison still hanging, because you've already done 1 year of it. Make sense?
So in each of these sections, like probation, rider, and prison, is there a mandatory mental health counseling, something that would help that change process?
No, there's nothing mandatory in anything. There is best practices, right? So the prison system works off of the LSI scores and all of that. So there's mental health assessments and everything that goes on. Now, whether or not the judge ultimately mandates it, it's a whole different ballgame.
So he can stop when he wants to.
Yeah, absolutely. The judge can do whatever the judge wants to do.
Do they typically-
They have all the power, and typically the sentences are pretty structured. So most people have mental health treatment. Most people are required to get a high school diploma. I use that not loosely, because the vast majority of individuals that are convicted of felonies do not have a high school diploma. So those type of things, they may be required to get vocational skills or something to that effect. So drug treatment, right? If alcohol and drugs didn't exist, most of us would be out of a job, right? You just waved your magic wand and they just didn't happen. So once again, you know, there's just, I put this up here just in the aspect because sometimes the terminology is used loosely, is, you know, punishment is the penalty place versus the sentencing is the actual process and the stages of it, right? And what is actually going to happen. So, and then lastly, right, if I get my thing to work. Sometimes it works, sometimes it doesn't, right? And this is, these are the fourfold components, and this is the last aspect. So these are the 4 things that every single case that the judge is balancing. What is the protection of society? Is there a deterrence? I guess there's 5. Deterrence aspect. Is there even the possibility of rehabilitating this individual? Punishment and retribution, right, in that aspect. And then the restoration, making the victim whole, the restorative justice component. So the judge is balancing these factors on every single case of what is the most important in this particular situation. One doesn't supersede another, although number 1, I would say, if you're to say the most important, number 1 is the ultimate, right? That's the entire purpose of the criminal justice system, is to protect society. And these 4 kind of dictate how we're going to best protect. Is the protection to rehabilitate this person at this stage so they become a productive member, or is protection the punishment and the deterrence of that person as well as society? Don't do this. So does it make sense? Questions, comments, thoughts, concerns, inquiries? That is really the short nutshell of how the criminal justice system, or not the system, but the court process works. So question, yes, ma'am.
Do you have a statistic?
I'll make one up.
Of how many people that get incarcerated have to go back?
The recidivism rates?
Yeah.
Off the top of my head, I don't. So I will say the vast majority of people that go on probation complete probation. But by the time you get to the prison system in the state of Idaho anymore, unless you've committed like a major crime, lewd conduct, heinous felony domestic homicide, the odds of you going straight to prison is slim to none. Is you've usually gone to probation once or twice, usually gone to a rider, you failed that, you've tried your specialty courts, you failed those, and we don't have any other options, so you're going to prison. So by the time you go to prison, for most individuals, is you have not been successful in all the other resources in which we have as a community, and we don't know what else to do with you. Unless you go off and kill somebody or something, then you're probably going straight to prison or a lewd conduct or something to that effect. So questions, comments? Is this helpful? So hopefully it, at least when you're working with the clients that you are, you'll kind of get an idea of how the whole system sort of interacts and works and flows. By the time that person's arrested, before COVID, to the time that trial took place was usually about 4 to 5 months. So now who knows? 7 months since we've had a trial. We haven't had a trial since mid-February. So yeah.
When you take them to trial, sorry.
Yeah.
How often do you win? What is the percentage?
I would say by the time of trials, I'd say around 80% from the trial world. Once again, you never know the 12 individuals that you're going to get. And usually the cases that go to trial are usually the ones in which there are questions, right? That's why we have the trial process. If it's a slam dunk, I mean, the classic, right, is, you know, Bob has methamphetamine in his pocket and says, yeah, it's my meth. There's really no reason that case should ever go to trial. And you'll never see that case, which is why 95% of them resolve in some aspect. So.
Why do a lot of charges get pled down to disturbing the peace when it is a DV charge?
So the question is, why do a lot get charged or dropped down to disturbing the peace? It's facts, evidence. Once again, the probable cause standard is very low. And then we're contemplating how the rules of evidence are going to come out, how juries are going to ultimately decide. And is it better to run it to a jury with the possibility of getting nothing, or getting the domestic or the disturbing the peace conviction so we can at least get the treatment and aspects? Usually those cases, I would say, right, it's a he said, she said with no physical evidence. And then it's meeting with the victim, and if the victim isn't cooperative, then you're really up a creek. So you're trying to get some type of resolution, which would be the most common reasons why they're reduced.
If it was a felony DV, do you guys ever offer a misdemeanor DV, or do you normally just go to the disturbing the peace charge?
No, usually the felonies are misdemeanors. If you, in your hypothetical, we usually don't drop a felony to a disturbing the peace.
Okay.
So if we're going to reduce a felony domestic, it's going to be reduced to usually a misdemeanor domestic.
Okay.
Because felony domestic in the state of Idaho is very loose. There is, if you and I were household members and I pushed you down and you got a scratch on your arm, in Idaho, that's a felony.
I thought it had to be a certain size. Is that not correct? Okay.
It's a traumatic injury.
Okay.
But is that truly felonious? Right? If we were arguing about who was in the Masked Singer, right, who got uncovered, and I pushed you, I had no history, is it truly domestic? Those are the questions, and I think that's something that Angela Weeks and us have been trying to work on, is trying to identify those that are truly domestic versus those that are domestic on a piece of paper. And we've been trying to focus a lot more attention on what is truly a domestic. If it's truly a domestic, it's not going to get reduced to a disturbing the peace. Too, if I'm making any sense in that aspect. So questions, other questions, comments, thoughts, concerns, inquiries, anything at this stage?
Super helpful.
No, hopefully it was. So, yep.
Thank you.
So, and hopefully it helps a little bit understand the process. It's a complicated system, but it's a fascinating one as well. So, okay, we're done.
Thank you.
Thanks.
Thank you.
Thank you very, very much.